everyone, welcome back. I am Miss Sini and I'm an intern in LEXIS and Company. The topic which we are going to cover in today's video is Article 32 of Indian Constitution, that is Writ Petition. Article 3 of the Constitution provides a legal remedy for the protection of these rights against their violation by the state or any other institution or individual. It entitles the citizens of India to move this to Supreme Court or High Court for enforcement of these rights. The state is forbidden from making any law that may conflict with the fundamental rights. The fundamental rights are the rights that grant individual equality in every aspect, irrespective of race, color, state, religion, birthplace, or gender. These rights are mentioned under Article 12 to 35 of the Indian Constitution. They are predefined punishments in case of violation of these rights upon the discretion of the judiciary. So now let us understand what is Writ. Writ are the written orders issued by the Supreme Court of India to provide constitutional remedy to protect the fundamental rights of citizens from a violation. So let us see what some of the important facts about writs in India. Article 32 also empowers Parliament to authorize any other court to issue these writs. Before 1950, only the High Court of Calcutta, Bombay and Madras had the power to issue writ. Article 226 empowers all the High Court of India to issue the writ. Writs in India are borrowed from English law where they were known as prerogative rights. So now let us understand what is writ petition. A writ petition is essentially a court petition for extraordinary views asking the court to intervene in the lower court's decision. Under the Indian legal system, jurisdiction is an issue. Prerogative writs is given to the Supreme Court and the High Court of Judiciary of all Indian states. Parts of the law relating to writ are outlined in the Constitution of India. So there are various types of writ. Let us see what are they. The Constitution empowers Supreme Court and High Court to issue order of writ. So the types of writ are Hebes Corpus, Seratorium, Prohibition, Mandibus and Quo Warranto. So let us understand in detail about each of the writs. First is Habeas Corpus. Habeas Corpus is a writ that is enforced to protect the fundamental rights to liberty of an individual against unlawful detention. This writ commands a public official to deliver a detained person in front of the court and provide valid reason for detention. However, this writ cannot be issued in case of proceeding is for contempt of legislature or the court. Second is Seratorium. The writ of Seratorium is issued to a lower court directing that transfer for the case of review. Usually to overrule the judgment of lower court, the Supreme Court issues the writ of Seratorium in case of decision passed by the lower court is challenged by the party. It is issued in this case the higher court finds it matter over jurisdiction or lack of jurisdiction. It is one of the mechanisms by which fundamental rights of the citizens are upheld. Third is Prohibition. Prohibition is a writ issued by High Court to lower court to enforce inactive in the jurisdiction. It happens only in case the High Court of the discretion that the case falls outside the jurisdiction of the lower court. Writ of prohibition can only be issued against judicial and quasi-judicial authority. Fourth is Mandibus. The writ of Mandibus is issued to the subordinate court and an officer of the government of corporation or any other institution commanding the performance of certain duties or acts. Unlike Habeas Corpus, Mandibus cannot be issued against a public individual. The writ of Mandibus can be issued to order the completion of tasks or other cases it may require the activity to be ceased. Fifth is Quo Warranto. Quo Warranto is an issue against a person who claims or supposes a public office. Through this writ, the court inquires by what authority the person supports his or her claim. Through this writ, the court inquires into the legality of the claim of the person to the public office. This writ prevents the illegal assumption of public offices by an individual. Now let us see what are the status of writs in other countries. For the writ other than habeas corpus are discretionary remedies and have been known as a prerogative order in England and Wales since 1938. The writ of quo warranto and precedento are now obsolete. The modified name of Seratorium, Mandibus and Prohibition are mentioned under the new Civil Procedure Rule 1998 known as Squashing Order, Mandatory Orders or Prohibiting Orders respectively. Mandibus has been replaced by injunction in the United States District Courts. Also, the Supreme Court of United States grants ceratoria while the Supreme Court of other states grants review. So now let us get into the conclusion. Thus, it is clear that vast power are vested to the judiciary to control an administrative action when it infringes fundamental rights to the citizen or when it goes beyond the spirit of country, that is Indian Constitution. It ensures the rule of law and democratic system and has a proper check between the balance of all the three organizations. The philosophy of writ is well synchronized in the constitution provision to ensure the rights of the citizen and are not suppressed by arbitrary administration of judicial action. So I hope that this video helped you to understand the various writs. So we'll meet in the next video. Till then, stay safe. Thank you.